Hello again. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. Thank you for joining. Today is all about learning what it means to be a board member and mastering that role. We have Steve Black with us from law firm of the Carolinas that's going to lead us through the webinar. We will be taking questions. We'll try to hold those questions till the end, but if you do have a question that's on your mind, please type those into the Q&A section of located at the lower portion of the screen. If you're on a regular PC, you can type that in and I'll read those questions to Steve at the end. We also record this, and you can find the recording located. It will be on camsmgt.com under the board member resources page. So if you have a board member that may not be here today and you want to share it with him, you can send them to the camsmgt.com website, and you can watch this webinar and then many of our other ones. We've been doing webinars for about 5 years, so lots of great content. Steve has been a regular presenter, and we do enjoy his presentations. So with that, Steve, I will turn it over to you and let you lead us through this content.
All right, excellent. Well, good evening, everyone. Again, my name is Steve Black. I'm one of the partners and shareholders here at Law Firm Carolinas. Thank you all for taking the time tonight to come. I will make it beneficial to you. And for the new board members that are here, thank you all for serving your association. I have been on the board of directors of every one of the associations that my wife and I have lived in ever since I got out of law school, except for the one I'm currently living in now. So I've had 20 years of being kind of where you guys are sitting, in addition to doing almost exclusively HOA and condo work for the last 20 years. And tonight, I'm gonna be going fast. I'm gonna tell you up front, because we are gonna try to kind of combine my Board of Directors 101 course that usually takes an hour with the Board of Directors 201 course. Okay, so I'm going to go quickly. I've kind of picked out the best parts of each one, but I will leave some time for questions in the end. But as I tell people every time I present, if you stick with me for the rest of the evening, probably an hour, then you will probably know more than 80 to 90% of the new board members out there, okay, in the Carolinas. So I promise to give you some great content. To start off, if you've ever seen me present before, this is one of my favorites. The story is this. To answer the question, why do we have homeowners associations? Why do they exist? What are you guys supposed to be doing? What are you supposed to be protecting against? There was a case, I believe it was out in Arizona. Person bought a house on a cul-de-sac, new construction, bought their house, beautiful house, had a veranda. They could sit out every morning and drink their coffee and eat their breakfast, overlooking the snow-capped mountains out in the distance. Well, eventually somebody bought the lot across the cul-de-sac from them and started building a house. Well, the taller that house across the cul-de-sac got, the less view this homeowner got, and they got a little upset about it. I'm not sure why. They should have known a house was going to be being built there, but they did. And as the roof started getting put on the house across the cul-de-sac, that was really going to disrupt the view that they'd been enjoying. And so they looked and they found that they had some restrictions in the neighborhood that said your roof couldn't be that pitch. And so that homeowner turned them in. They had to rip the roof off that they'd put on and put in a lower roof like this. And I have a picture of the lower roof that was put on after they had complained. So this is a picture. The homeowner that was building the house says that this was a venting system for the attic. That's not what I see, but I'll take it. The next one is also a fun one. This is a mailbox in a neighborhood. I have my own theory, just my own story, that this is probably pointed at the neighbor's house with a dispute. That's just me. And then this is a relatively new one. I've never used this one before, but imagine that you have no signage restrictions in your restrictive covenants. People can put signs in their yards. They can put security signs in their yards. They can put yard sale signs. They can put those happy birthday signs in their yard. Well, what if they put this in their yard? Do we have anything we can do about that? So those are kind of the introductory reasons as to why we have homeowners associations, what you guys are trying to help with and prevent, and it's certainly important. So we're going to start off with some of the real basic stuff. Directors and officers, people kind of change those words, and I think it's important that we use them right. Directors are the board of directors. Those are the people who are elected to those seats. They make all the decisions. Okay, they can spend all the money, they can enforce all the restrictions. Officers are executive positions on the board of directors: president, vice president, secretary, treasurer. Okay, and those offices can move around. Steve can be the president one day, Ben can be the president next day, but we're both board members. So just to kind of get our language right on that. Standard of care. If you haven't already asked yourself, what am I supposed to do? How am I supposed to do this job as a volunteer board of director? Okay. This is the answer. This is what the law is requiring. Number one, you have to act in good faith. What does that mean? That means that you don't act in bad faith. Okay. I hate that I don't have a better definition for it, but really good faith means in the best interest of the association, your decisions. In other words, the decision you make is in the best interest of the entire community and not just you or not just your friend down the street. Okay, so operate in good faith for the best interest of the association. And then also to use the care that a reasonably prudent person would use in a similar circumstance. What does that mean? That means you need to be prudent in your decisions to the standard that other board members in the country or in the state may use. Okay, so measure yourself against a good, reasonable, prudent person in the same position. Now, been doing this a long time now, 20 plus years representing HOAs and condos. And I can tell you the next one is where people trip up, and many times not intentionally. Uniform actions and enforcement. Okay, you got to treat everybody the same or substantially similar. Okay, and let me tell you where people trip up on that. You got Bob, okay? Bob's in the neighborhood and Bob is a pain. He's always been a pain. He's just a thorn in the side. And then you got Sarah. Sarah's very nice, has done a lot for the neighborhood. Everybody loves Sarah. Okay, she throws the parties and everybody enjoys Sarah. Bob and Sarah are both delinquent on their dues. You got to treat them the same. Bob puts up a violation in his yard. Sarah puts up a violation in her yard. You got to treat them the same. Okay, you can't say, hey, let's call Sarah and talk to Sarah first. Okay, without calling Bob. So uniform actions and enforcement is really a kind of a minefield for boards. You don't intend to do it, but it happens. The last one is probably the most important one, and that is use good business judgment. There's the business judgment rule, and all that means is that you have to act like a business. And that's really hard. Like I mentioned, I've been on the board of directors of my associations for 20 years. You want to be a good neighbor. You want to be a good friend sometimes, but that's not the standard. The standard is to be a good business. Okay? And many times those are not the same thing. So the decisions you make have to be business judgment decisions and not kind of neighbor judgment decisions. If you haven't asked yourself the second question, I'd be surprised. I just signed up for this. I'm a volunteer. I'm not getting paid. I haven't been trained really to do this. How much trouble can I get myself in personally, individually? What's at risk for me? I'm going to tell you not to worry about that too much because there are multiple layers of protection for you. Number one is indemnification provided by the governing documents. That's fancy language for in your HOA rules. I can almost guarantee that there's language in there that says if the association gets sued or if you get sued individually, that the association has a duty to step up, find you a lawyer, help pay for your lawyer, or pay for your lawyer to protect you. If your governing documents don't say that, which would surprise me, the nonprofit acts, both North Carolina and South Carolina nonprofit acts, both have the same indemnification requirement. So the association's got to step up and help you. More likely, you're going to use the directors and officers coverage. Okay, directors and officers insurance coverage is a policy that the association should buy. You need to ask your manager, but I'm sure you have it. That's very reasonably priced, and it is designed that when the association gets sued and the board members get sued, that you make a claim on the insurance policy, they hire an insurance defense lawyer to defend everybody in the case. Okay, very good stuff. It's used all the time. Now, you can always be named in a suit. Okay, you can always be named in a suit, but you should be defended, as I mentioned, by the association or the insurance carrier. And it's likely that it'll be dismissed against you individually. Likely, not guaranteed, but it's likely that the case will be dismissed against you individually. Now, all of what I just told you is premised on the fact that all of that protection is only available to you if you've operated in good faith. Okay, and remember a couple of slides ago, we talked about good faith, doing what's in the best interest of the association, not doing what's in only your best interest. Business judgment rule. All of those things will help you get this kind of protection and coverage. All right, next we're going to talk about the laws and the documents. This is pretty straightforward stuff. Obviously, we have to follow federal law. Okay, a lot of times that's fair housing. We're going to talk about that in a minute. State statutes. Okay, North Carolina has a lot of very specific laws for HOAs. South Carolina less so, but they do exist. And then you've got your local ordinances and your municipal issues. Governing documents of the association. You're going to hear me say that a lot tonight. People get this wrong all the time, and I want to help you with that. The most authoritative document is the declaration. Okay, the Declaration of Covenants, Conditions, and Restrictions. That's that 50 or 60-page document that hopefully you have by now as a board of director. In South Carolina, sometimes it's called a master deed. That's where all the meat is, I'll call it. Okay, that's where you have to pay dues. That's where you can't have farm animals. That's where you can't have chain link fences. That's where you have to get architectural control. That's what you're going to be using a lot, right? Articles of incorporation, that's the document that created the association as a corporation, as a nonprofit, most likely. You're probably never going to see that or look at it. The bylaws are the document that tell you how to run the company. Okay, how many board members do you have? How often do you have to meet? What kind of notice do you have to give for meetings? So it's kind of the operational document for the association. And then the last one, the least authoritative, is board policies. Collection policies. When do you turn people over for collections? Enforcement policies. How many letters do they get before you kind of put the hammer down on some enforcement issues? And those are board policies. And here's the point I mentioned. Many times I hear board members say, well, the bylaws say you can't have chain link fences. Well, that's not technically correct. Okay, it's the declaration or the master deed that says you can't have a chain link fence. The bylaws usually don't say that. Okay, the bylaws tell us how many years the board terms are, how long you get to serve, not the declaration. So just be aware that you're usually talking about the declaration or the master deed and not the bylaws when you're talking about enforcing things. All right, speaking of enforcing things, enforcing the HOA governing documents. When people violate the restrictions, what do we do? And again, let me back up. Let me say that this and architectural control, these two things are when our associations get sued the most often. Okay, so let me just make that strong point. When you're enforcing things, somebody's violated the restrictions. They built a pool that they're not supposed to build or put up an above ground pool when they're not permitted. What are the options? Option number one, sometimes your governing documents will give what I call self-help authority. It may even say in there that upon 20 days notice, sending them a letter, 20 days go by, we can send people over to take out the above ground pool. Sometimes that's out there in the declaration. I have never in the history of my practice recommended that an association take that approach. Okay, we have a lot of other tools in our toolbox to help enforce. I never recommended that we go on and disassemble something or remove something for obvious reasons. Injunctive relief. That's another way we can force a homeowner to comply. This is in court. Okay, injunctive relief is a court order ordering someone to do something or not do something. Okay, take down the fence, repaint the house. Very expensive, time consuming. So, but that is the kind of the ultimate remedy for us is to go to court and try to get a court order for that. Far more often, we do internal fining. Okay, in North Carolina, we have a statute that gives almost all associations authority to fine owners for violating the restrictions. South Carolina, Most of them do. The governing documents give authority to fine. It just may be in different ways and different processes that you have to follow. So, but fining by far is the most effective way to get compliance of homeowners who violate the restrictions. When you are fining people, okay, in North Carolina, we got a statute and it helps us with the steps of what you have to do before you can fine somebody. South Carolina, it's almost the same usually in the documents, but there may be additional steps or real specific steps you have to take before you can fine people. But the point is, there's a process to fine in almost all cases. Step one is to give notice of the violation. Okay, in other words, we see you put up a fence. We don't have an architectural application for that fence. It hasn't been approved. Therefore, we think it's a violation. Okay, then you send them a notice. Your management company is going to do most of this, by the way. They're very familiar with this process. They already have all the letters, all the forms, and they do it every day. But you send them a notice. How do you send that notice? Can you just email it? My suggestion strongly is no. You can't just email it. Okay, the law's getting there, but we're still some time away from that being effective notice. Can you just send it regular mail? Just send a letter that's a notice of violation. My position is yes, you can. Just a first-class letter. Do you have to send it certified mail? My response is no. The statute doesn't require that it be, in North Carolina, require it to be certified mail. And our standing advice is there's no need to send it certified mail. There's something in the law called the mailbox rule, which means if you put a letter properly addressed with the proper postage on it into a USPS depository, it is presumed to be delivered. It's a great rule, and that's what we rely on for just regular mail. How much notice do you have to give someone for a hearing? Okay, so the fence isn't approved. You want to start fining them. We've sent them the notice of violation. How much notice do we have to give them for the hearing? There's no law on that in North Carolina or South Carolina about what's reasonable notice. We say 10 days. Okay, 10 days is enough notice for a hearing. But again, that's just our advice. Then you got the big one, okay? The opportunity to be heard. That's a hearing. Okay, before you find somebody, especially, well, in North Carolina for sure, you have to give them a notice and an opportunity to be heard, or a hearing. Okay, an opportunity to defend themselves, to tell their side of the case is what that is. In South Carolina, there's some other options possibly, but that's driven by your governing documents. The hearing can be virtual. In fact, most of them are virtual nowadays. And, the way my style is, I invite people to come to the hearing with a notice. They show up on the screen or in person, and I say, look, we've got some complaints about some things. It looks like there's a violation on your property. We're here to talk about it, to see if we can work this out and see, what options exist. Tell me your side of the story, homeowner. Tell me what's going on. Okay, so it's not a real formal thing, because many of these hearings are done without lawyers, and you're just neighbors kind of talking. We're a board and the member talking, and there's no reason to be unnecessarily adversarial. At the end of the hearing, okay, the homeowner has spoken their piece, the board has spoken its piece or the information it has. We can excuse the homeowner, they leave, and then the board deliberates. Do we think there's a violation? Yes, we have no architectural application for that fence. They admitted not having submitted an application for the fence possibly. And so, yes, there's a violation. And number two, what fine amount, if any, is going to be imposed? Right? And in North Carolina, you can fine up to $100 for a violation, and possibly daily until the violation is cured, up to $100. And in South Carolina, it's driven by the governing documents again, as to how much you can fine. One of my favorite cases of all time, the point of this case is to impress upon you as board members that yes, you should enforce the restrictions. Yes, you should use the fining authority to do that. And yes, you may end up fining some homeowners for violations, and things may get, somewhat uncomfortable with that. When you're looking at fining and enforcing, My point is the law has, for the last 10 years, in both North Carolina and South Carolina, the law and the cases out of the courts have made it very, very clear that the restrictions or the rules that you're enforcing have to be very clear. Okay, they have to be unambiguous. They can't have multiple meanings. Okay, now what does that mean? This is a great example of this case. This is Fred and Barney. Okay, they're Nigerian dwarf goats. And this is a real case, by the way. Homeowners got Fred and Barney, brought them home to their neighborhood that has a homeowners association, and dressed them up in little sweaters, walked them around on leashes. The evidence was that they could actually fetch, that they had little beds in the garage, I guess dog beds or goat beds or whatever you want to call them. And the association sent them a letter that says, I'm sorry, but our restrictive covenants prohibit livestock in the association. Okay. They fought about this. They went to district court. They went to the Court of Appeals. I mean, it went all, they litigated this thing for a long time and spent a lot of money. And in the end, the court said, yes, your restrictions say no livestock, but under these facts, they wear sweaters, they get walked on leashes, they can do tricks, they sleep on beds in the house or in the garage. So they're actually pets. They're not livestock. And Fred and Barney got to stay at home. Okay. Now, the point of that is to tell you, you may think you're looking at some pretty clear language. I mean, I thought I knew what livestock was. Okay. But courts really wanted to say maybe no goats or no Nigerian dwarf goats. Maybe that's what our restrictions had to say to prevent this. I don't know. Because using the court's logic, and this is my favorite part, using the court's logic, if I lived in this neighborhood and I brought home a cow, which is like the definition of livestock to me, and I put it in a sweater, I put a leash on it, I walked it around, maybe I can teach it a trick, let it sleep in the garage on a big mattress, it's no longer livestock. That's just, it's hard to understand that ruling, but that's a great example of look at your restrictions very carefully when you're starting to enforce them and when you're thinking about fining people. All right, the next big way that associations get sued and board members can get into trouble is architectural control. Okay, that's when you tell people, yes, you can have that. No, you can't have that fence or outbuilding or whatever it is. Number one piece of advice is read your documents. Okay, it's probably Article 4 or 5 of your declaration. It's about a paragraph, maybe 2 long. It's not very long, but read that. Okay, architectural control or architectural committee. That'll tell you what the guardrails are. 90% of the time, the standard is it consistent or in harmony with other things in the neighborhood? Okay, let me explain. Let's say you have black wrought iron fences throughout the community. That's the standard, right? That's what's consistent. That's what's harmonious. Well, somebody comes and applies for a 6-foot high white vinyl privacy fence. Okay. Is that consistent with what's here? Is that in harmony with what we already have? And you can swap out fence for anything, a shed, a bench, it doesn't matter. But do we have other things like it in the community already? Is it consistent and in harmony? If it is, chances are you need to approve it. If it's not, chances are you can deny it. But what you're going to find is there's a whole lot of space in the middle. And that's where it gets kind of tough. Okay, but I just wanted to explain to you what the standard is almost every time. Is it consistent and harmonious? What duty does the ARC have when it denies an application? So let's say that you deny that 6-foot tall white vinyl privacy fence because all we have is wrought iron, right? You have to respond in writing. And again, your management company does most of this. You have to send them a letter that says, I'm sorry, this is denied. You have to tell them the reason that it's denied. In this case, it's not harmonious and consistent. We have a lot of wrought iron in the community, and that's why we're denying your application. But, fill in the blank. Is it a shed? Is it, columns? Is it pergola? Is it a trellis? What is it? Respond in writing, valid reasons for denying it. And the other tricky one, the law says technically we're supposed to offer suggestions. as to how to improve their chances of getting it approved. Okay? In other words, I'm sorry your 6-foot white vinyl fence is denied. However, if you'd like to resubmit an application for a 4-foot tall fence, maybe white vinyl, maybe black vinyl, I don't know, but make suggestions on how they can improve their chances to get approved. This is new for me. Someone sent this to me, and I think it is fantastic. This is, for those of you who are not Star Wars fans, this is what appears to be a 40-foot tall AT-AT from, I think it was Empire Strikes Back. So, does this require architectural approval? Yes. Okay, most likely. Is there going to be something that's harmonious and consistent with this? Probably not. It's probably going to be denied. So you can see the picture at the bottom, the proud father with his very excited son, I'm sure. Get Dad of the Year award, but I'm afraid that's going to have to come down. And it's actually a treehouse. If you notice, there's stairs in the back. So very creative. I will also point out, just for fun, look behind the bottom picture. Okay, see the AT-AT and the father and the son. Look behind the fence. What do you see? Brand new houses under construction. Okay, you can imagine the builder or the owners of those is going to be going crazy, emailing the board of directors, emailing the association, and saying, what are you going to do about this? Board meetings. How do we run board meetings? What's the best way to do it? When are they? Where are they? How often? Board meetings can be in person. Okay. They can be anywhere. They can be in somebody's living room. You can go to the clubhouse if you want. They can actually be virtual. Okay. How often you meet as a board of directors? Most bylaws, and remember, bylaws are the document that will most likely tell you, because they're the operational document for the corporation, may tell you how often you should meet. A lot of times they're silent on how often the board of directors has to meet. And it varies greatly. Okay. If you're a very large community with lots of amenities, a pool, a clubhouse, walking trails, an equestrian center, then you're probably going to be meeting once a month. Okay. No more often than once a month, usually. A lot of boards meet every other month. Some meet quarterly. I don't know of any boards that should be meeting less than quarterly. But that's just through my experience. Quorum. Quorum is in the bylaws. It's usually a majority of the board. So if you have 5 board members, 3 of you showing up can do every piece of business necessary. Okay, so a majority of the board members need to be present in person. Interesting fact, a lot of people don't know this, you can't use proxies at board meetings. So in other words, Steve's on the board, Ben's on the board, got 3 other board members. Steve can't make it that night. Okay, got to work. So I give Ben my proxy to go to the board meeting. You can't do that. Okay, proxies can be used for membership meetings for homeowners to use if they can't make it, but not for board meetings. And the theory is, and it makes sense, is that as a board of director, you're a fiduciary. Okay, you have fiduciary responsibilities to the company and to the membership, and you can't delegate fiduciary responsibilities. You can't assign them to somebody else. You can do board meetings by telephone. That's fine. You can do them by video. A lot of people do them by video now. And the rule there is, as long as people can hear and participate. Okay, so however that happens, phone, video, then it's fine. I usually do it when I do this presentation live. I will have people show hands as to the longest board meeting they've ever been in for their board. And you might be shocked. And what I've learned over the years, and being on my own board of directors for many years, is board meetings run entirely too long. Okay. And, maybe you like your board members. You're just sitting around talking, chatting, gossiping, what have you. But a board meeting should really be no more than about an hour. Okay. If it's more than an hour, that means one of 2 things. One, you have some serious issues going on, and you should be meeting for more than an hour. Or 2, you're probably wasting time. Okay. So an hour should be your target or less. Here's the key to that. The presiding officer needs to be a strong presiding officer, because they're the key to keeping meetings on track. Sounds silly, I know, but have and use an agenda. It takes about 30 seconds to put together an agenda. Bullet point 1, bullet point 2, bullet point 3, bullet point 4. Maybe your manager can help you with some ideas on how to put that together, but it truly does help. Park digressions. Okay, I'm going to take a minute on this because this is golden. Having been on my own board of directors for many years, you're there. It's 7 o'clock on a Tuesday night. You're in Sarah's living room. You know, she's got sodas and brownies for everybody to eat. It's a very relaxed, nice atmosphere. You're just going to end up talking. You know, hey, did you hear that Johnny down the street, you know, him and Pat, Patricia are getting a divorce? Did y'all hear that? See, park that. We're not talking about that. That's not on the agenda. Let's get back to the agenda. If they want to talk about something that's not on the agenda and not proper for the evening, of the business for the evening, that's another thing you can park. Hey, I'll tell you what, that's a good point. That is a topic we need to talk about, but let's park that for now. Okay, let's park that for now. We'll come back to it. Maybe this meeting, maybe next meeting, maybe 3 meetings from now. But just try to keep people on track is the point. I heard this from a very smart person many years ago, and it works really well. And you can use this in your business. You can use this with your HOA. Equalize the discussion. Every board of directors and every group that you're going to be in life has talkative people and quieter people. It has what I call the steamrollers and the non-steamroller people. As the presiding officer, whether it's the president, vice president, whoever's presiding over the meeting, it's your job to draw out people who aren't talking much. Okay, let's say Stan. Stan is going to give you his opinion a lot and verbose. Okay, well, what does Jill think? Jill, you haven't spoken on this. What do you think? That's what I'm talking about. Draw people's opinions out. Okay, try to equalize things. Let everybody have an opportunity to speak. Now, if you hear nothing else from me tonight, the next one is worth your time of attending. Is there a motion? That's 4 words. Is there a motion? A magic phrase to keep meetings on track, to keep meetings from running too long. How do you use that? If you get into a discussion, let's have blue flowers at the front entrance. Jill, what do you think about blue flowers? What about red flowers? What about flowers, flowers, flowers? We've been talking about it for 20 minutes. This shouldn't be this long. It's not that complicated to pick flowers. Is there a motion? Anybody can ask it. Is there a motion? Oh, yeah. I make a motion that we do blue flowers. Second, all in favor? Aye. Yep. Majority, done. It's a way to focus the discussion. It's a way to focus the business to get it done and keep people from really just kind of droning on and on about something that shouldn't take that long. Now, that's not designed to shut people up, okay? I make a motion that we do blue flowers. Second, great, vote, and then it fails. Nobody, people don't want blue flowers yet. All right, we're going to discuss it some more then. But it's a way to use Robert's rules in a very effective way. Can you do action outside of a meeting? Okay, in other words, you're at Sarah's house, you've had the meeting, you've done a lot of good business, there's been a lot of motions brought up, a lot of motions have passed, you're done in hopefully less than an hour, and 3 days later something comes up. Manager calls or emails the board of directors and says, we've got this issue. What do you want me to do? You don't have to call a meeting, okay, of the board. You don't have to physically get together or virtually get together, but you can do business outside of a meeting, without a meeting, but it has to be unanimous, okay? And let me tell you, boards hate that answer. Managers hate it worse, but that's what the law is unless you're at a meeting, a duly called meeting, you have to have unanimous approval of all the board members, okay? Let's play that out. Got 5 board members. Insurance claim needs to be filed. Manager says, hey, we've had a water pipe burst on the 4th floor of the condo. We need to, my suggestion is we make an insurance claim. Do I have authority to do that? That's the email. 4 of the 5 people, board members, respond. Okay, just 4. It's not authorized yet. Okay, and people trip up on this really often. 4 is a majority, clearly. But if it's outside of a meeting, you're supposed to have 5 to make it legitimate. Okay. Now there's other ways we can do that, but just kind of as a general rule, that's what I'd like you to walk away with. And the problem is, as some of you are probably shaking your head right now, I imagine there's one person that doesn't respond to things, and that makes things really difficult. So if you have that situation, there are ways around it, but for the most part, that's the safest way to do it, especially on big decisions, especially on big decisions. I'm sorry. The last point there, it's best to include those in the next minutes. So let's say we had 3 pieces of business come up by email between our board meetings, and we had 5 people approve, all 5, all board members unanimously sent in emails that said yes, 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 yes. That should be brought up at the next meeting and stated in the minutes. Okay. Doesn't have to be. You've got the emails as a record, but it's much, much cleaner just to try to stick them in the minutes, if you can remember. Speaking of minutes, my secretaries, I'm talking to you right now. Minutes are a record of what was done at the meeting, not what was said. Here's the difference. What was done? They decided to put in blue flowers at the front. That's what was done. They decided to make an insurance claim for the water pipe burst yesterday or this morning. That's what was done. What secretaries tend to do, and I get it, I was the secretary early on, is you want to write down everything. Well, Bob thought they should be red flowers, but Jill thought they should be blue, but then she changed her mind to blue. It doesn't matter, okay? It's just what was voted on and what was decided. Okay, so your minutes should be half a page, maybe a page if you had a lot of business to do, okay? And let me tell you why I'm spending so much time on this. I have lost more than one litigation case in my career because the secretary was overly zealous on the minutes. Let me explain. I had a case, this was quite a while ago now. The secretary would come to the meeting, and I think she was doing shorthand actually, and recording the meeting on a dictation machine, and then she would go back and basically transcribe the entire meeting. Okay, so the minutes would be 3 pages, 4 pages, single spaced. That's before I represented them. They got sued for discrimination. And the first thing that plaintiffs' lawyers do, every time, all the time, is ask for the minutes of the association for the last 2 or 3 years. Okay, that's the very first thing out of the gates. Well, I had to go through those minutes that the secretary had done for those many years. And the plaintiff's lawyer caught on to, buried on page 3 of some minutes somewhere, paragraph 4, line 7. They were talking about something completely unrelated, but it said something like, well, we have to get those kind of people out. Okay. Secretary didn't need to put that in there. I don't even remember what it was about. It wasn't about this case, but let me tell you, that plaintiff lawyer waved that around like a flag in that case, and they had to pay some money. Okay. Closed sessions for the board meetings. In North Carolina, there's actually a statute that says that board meetings have to be open to the public, to the general membership, with reasonable frequency. Okay, that's what it says. Nobody knows what that means. What's reasonable? I would suggest that it's at least 25% of your meetings should be open to members coming. I mean, ideally, you wouldn't care if members come, really. Our meetings are open. But you absolutely have to do it with reasonable frequency. Your governing documents may change that, make it more, can't make it less. South Carolina, same thing. It's in your documents. Either way, you can go into what's called a closed session or executive session. Maybe you've heard it that way. Executive session should be used, okay, but I'd say very sparingly. If you're talking to your lawyer, absolutely. Executive session, closed session. If you're talking about litigation, prospective litigation, yes, clearly. Where it gets a little fuzzy is if you're discussing sensitive information. Okay, well, what's sensitive? Delinquencies, yes. Maybe enforcement matters. If you're about to go pursue, Jimmy for his above ground pool, maybe that's a sensitive issue you need to go into closed session or executive session for. And then discussing contract terms. If you're negotiating with your landscaper, you certainly don't want that to be, public knowledge to the membership. put you at a disadvantage. But definitely disciplinary matters. The hearings I was mentioning earlier, before you find people, those should be considered closed sessions or executive sessions as well. Now, there's no hard and fast rule as to when you absolutely have to go into executive or closed session. Okay, you can pretty much go in whenever you want to, but I would tell you that going in too often and kind of kicking members out or not letting members participate, that just breeds, distrust. It breeds secrecy. And a lot of times that's very unnecessary and causes problems you really shouldn't have. So use it wisely, but definitely when you're talking to legal and discussing litigation. This kind of says what I was mentioning. You should keep your meetings open if you can on a regular basis. Minutes, secretaries. You should have minutes for the open session of the board of directors. Okay, we chose blue flowers, we did these things, and then you should have separate minutes for any closed session or executive session. We went into closed or executive session to discuss the enforcement issue against Jimmy and his above ground pool, and this is what was decided. Different minutes. Email blasts are good for open session things. The more information, the better for stuff they could have heard anyway. And then other town hall type meetings, more information is better. Everybody knows that. It's hard to do. And it's hard, especially when you're busy and you're just a volunteer, but it is good to distribute information. All right, here's some of the trouble spots for board members. This is the quicksand. Acting without proper formality or acting alone. Okay. That's that whole discussion I was just mentioning to you. That, look, if you're at a board meeting, a properly called board meeting, virtual or in person, and a majority of the board members are there, that's fine, proper. If you're not in a board meeting and you've got all 5 of a 5-member board emailing okay, perfectly fine. But if you're at the board meeting at Susie's table, and there's only 2 of you that showed up, and you make a decision and you do something, or you don't get unanimous emails from everybody, okay, outside of a meeting, you're pretty much acting alone, okay? And that's bad for a lot of different reasons. Not being fair, being perceived unfair, that goes back to one of the first slides about treating everybody similarly. I cannot tell you how it happens daily, really, in this office, where you chase somebody about their fence, you chase somebody about their barking dog, you chase somebody about this. The first thing they say is, well, there's a dog barking on the other side of the neighborhood. Here's 3 pictures of a fence that's very similar to the one I want. It happens all the time. So try to avoid putting yourself and your association in those positions. All right, I haven't talked about this at all tonight, and I want to make a big point about this. One of the best ways to make good decisions, good business judgment, treating everybody fairly, and all that laundry list I gave you about good faith, so you can have your protections under the law, is to use professionals, okay? For example, if it's a legal matter or smells like a legal matter, ask the lawyer, okay? Now, do we cost money? Of course we cost money, but if it's a legal matter, you need to spend the money. If it's a plumbing problem, talk to a plumber. If it's an architect problem, deal with an architect. If it's something the manager may know due to their skill and training, ask them, okay? Use professionals. Here's how this plays out. Somebody got hurt on the common area. Little kid got hurt on the playground, okay? The plaintiff's lawyer is going to come after the association hard and the association's insurance carrier. And their case is going to be that the association never took care of the playground, never tested the equipment, never looked at it, never inspected it, right? Maybe, if we're lucky, Billy, neighbor, kind of looks it over, once a month, okay? That's probably the evidence that we would have. Not good. Not good. Did we have an expert person check it out once every year? So much better. So much better. Professionals, plumbers, architects, lawyers, CPAs, contractors, drainage experts, pond maintenance people. Use them. Fair Housing Act minefields. This is my favorite part of the presentation. I've actually added some slides to the end that I'll hold off on that. I have a couple of examples of board members going rogue, and this is largely for entertainment, but it makes some really strong points. The antenna tower case. Association president was walking down the street with his dog. Homeowner comes out and says, hey, Jimmy, whatever his name was. Hey, Jimmy, I want to put a ham radio antenna kind of on the side of my house, because I'm getting into that. That's not a problem, right? Jimmy said, nope, that's fine. Go ahead. Okay. Because in Jimmy's mind, that antenna was about this big. Okay. Jimmy doesn't know about ham radio antennas. Well, the homeowner, relying on the president, goes and builds the largest ham radio antenna I've ever seen. It actually was on a metal tower frame that was probably a foot wide. Up the side, the antenna spanned sideways about the width of the roof of the house. Right? When we said, hey, you got to take your antenna down, you don't have approval. Yes, I do. Terrible case. Even worse was the Bodine versus Harris case. This was a case we did years ago that actually went to the Supreme Court of North Carolina. The homeowner wanted an in-ground pool, okay, and a pool house, and staked it out, just wooden stakes in the ground, okay. And the president, I think they were friends or pretty close acquaintances. They were talking one afternoon, and the homeowner pointed out the stakes and said, hey, here's where the pool's going to go. Here's where the pool house is going to go. And we're going to have a bar in the pool house and TV. It was going to be very nice. It turned out to be very nice. And the president said, I can't wait to have a beer at the bar. Right? Can't wait to have a beer at the bar. I heard that a dozen times during the jury trial that we had to have, because the homeowner said, I got approval. Part of my approval was the president saying that. Okay. So if you could imagine yourself doing something like that, because it's very easy to do, be aware, huge problems. Huge problems. Okay. Here is more of the advanced part of the presentation. Fair housing. If I had to pick a third or fourth way, architectural control was number one, enforcement issues were number two for associations getting sued and getting into trouble. Fair housing is probably number three or number four, okay? Of course, you're not going to discriminate against homeowners. That's what you're thinking. Of course I'm not. I would never do that. I have 4 cases on my desk right now where the board thought that, the homeowner disagreed. So it happens a lot. You can't discriminate against people based on race, color, religion, sex, national origin, family status, which means how many kids you have, or handicap. Well, of course, I would never discriminate. I'm going to just take 2 of them because they're the most common problems we see and explain those for you. One of the protected classes is familial status. That has to do with how your family is comprised. Primarily how many kids you have or that you have children, right? Policies and procedures that mention children or minors. Minefield, okay? Let me tell you what I mean. And boy, this is a hot topic. No children under the age of 12 shall be at the pool without adult supervision. Sounds incredibly reasonable. Of course it's reasonable, but it's illegal. It's a violation of the Fair Housing Act. Okay? No children, I saw this not too long ago. No children can play in the parking lot of the townhome community. Guess what? Violation of the Fair Housing Act. I could go on and on. But my point is this. If your policies or your procedures or even your recorded restrictions say the words child, children, minors, anything that kind of carves out children and treats them differently, very, very likely that you have a fair housing problem. And we need to look at that. Same thing. Any language regarding conduct more specific to minors. I'll give you a good example that's kind of on the line. No bicycles, skateboards, what was the other one? Or scooters shall be left in the common area of the condominium after 5 p.m. Seems reasonable. Is that really geared towards children? Probably. I mean, do adults ride bicycles and scooters and skateboards? Yes, they do, but you see my point. It's certainly something to look at. And personal property related to minors, same thing, skateboards, scooters, that sort of thing. You got to be really, really careful with. So what am I trying to tell you there? When you're the board of directors and when you've got an enforcement issue that's come up and you see the word minors, you're trying to enforce something about minors or children or under the age of 18 somehow, then red flags should just be popping up. The other one that my boards get into trouble with is handicapped people. Okay, they are a protected class, and we have to treat them with a couple extra steps. The association is required to provide reasonable modifications to the common elements, common area, or reasonable accommodations for any rules and regulations that we have to accommodate disabled people. Okay, what does that mean? Let's say a homeowner says, hey, I'm disabled, I'm in a wheelchair, and I need a ramp from the curb of my townhome sidewalk to the parking lot. They're asking for a reasonable modification to the common elements. Can I put a ramp in the common elements? Right, that's what that is. And there's some steps and processes we need to go through to analyze that and hopefully approve it if possible. Reasonable accommodations. And boy, this is a hot one. I mean, I never thought when I was in law school that I would come to work and talk about emotional support chickens. But I have 3 of those cases right now. And the case is someone has an emotional issue and they've got a doctor's note that says they need 3 chickens. They need 3 chickens at this townhome community or condominium community or the single family community. The association has a duty to reasonably accommodate that disability. Okay. Now, I'm not going to tell you whether they get to keep the chickens or not keep the chickens because it's very fact specific. But what my job is tonight is to tell you, if you have someone that's clearly disabled, they're in a wheelchair or they're blind or something, then flags should just be going up if they ask for something or ask for an accommodation. Sometimes the mental issues, the emotional issues, those are much harder to spot, obviously. And so, but just know that if someone says, I need this, I need to break the rules, I need to bend the rules, I need something special in the common elements, that flag should just be going up and you should be asking the attorney for the association, is this a fair housing issue? All right, last couple of slides and then I'll take some questions. I did a presentation not too long ago, which was one of my favorite of all time. And we did a mock trial. Okay, there are about, I don't know, 100 managers there, association managers on fair housing. We did a mock trial where we had a plaintiff and a defendant association. The plaintiff was the homeowner. Okay, the defendant was the association. We had one of our lawyers dressed up in a judge's robe. And the case was this. The case was townhome community. Let's say Sarah. Sarah has lived in her unit for 20 years. Next door to her were the Smiths. They got along great for a long, long time. The Smiths moved away and sold the townhouse. They sold the townhouse to the Johnsons. The Johnsons move in, okay, 2 adults, parents, 3 children. That wasn't the problem. The problem was that the Johnsons who moved in were professional clowns. Okay. The neighbor, Sarah, who'd been there for 20 years, she had coulrophobia. I think is what it's called. Coulrophobia is a diagnosable fear of clowns. Okay. Tried to make it fun. And she had and what was happening was the Johnsons were they're training their children to be clowns. Okay, because they were professional clowns. And so every day from 3 o'clock to 6 o'clock at night, they'd be in the backyard of the common area outside the townhome, teaching their kids how to honk the horns and spray each other with flour and water and play circus music all night during the training. And that would send Sarah just into the bedroom. She couldn't eat, she couldn't sleep, she couldn't work because of her coulrophobia. Okay. this was for fun, a picture of the Johnsons that had moved in, and Sarah had a note from a doctor at Duke in our hypothetical mock trial saying that she was diagnosed with calorophobia and that as a direct result of the conduct next door in the townhome, she couldn't eat, sleep, had lost weight, couldn't work, couldn't make money. And so Sarah was asking the association to pay for and install a 12-foot tall wooden privacy fence that extended from the back of the townhome all the way out into the common area so that she wouldn't be able to hear, okay, or I'm sorry, see the clowns training. And also to install a bunch of bushes and sound dampening devices and these things in between the townhomes so that she couldn't hear the circus music and couldn't hear the horns, etc. I know it's kind of outrageous, but it made the point. So we put on this little mock trial. Oh, I forgot another favorite part. Sarah also needed, unrelated to the clowns, an emotional support animal. And the only emotional support animal that would help Sarah is this peacock. Okay, it's like a Titanic peacock, the largest peacock in the world. And her letter from Duke Hospital said she absolutely has to have this peacock. Can't be another bird, can't be a parrot, parakeet, can't be those. It has to be this bird in her townhome. And if you don't know anything about peacocks, they screech at about 100 decibels, and you can hear it for half a mile. So the mock trial was, is it a reasonable modification request for the fence and the sound dampening equipment because Sarah has a provable disability? What's a reasonable accommodation? What does the association have to do and have to allow? So we put on a full little trial there, and then we let the audience vote. They'll scan they scan it with their phone. They got to vote on what wins and what loses. And I'll just tell you the end of it was, in that case, with that jury of 80 people in the audience, they ruled that no, it was not a reasonable modification request. It was not a reasonable accommodation request to have the bird and to require the walls in our little mock trial. But it was fun and it made the point. All right. That's what I've got for this evening for you. What questions do we have?
Lots of questions have come in.
About peacocks?
Absolutely, all about peacocks. I'll mention, just since talking age restrictions, we do have some 55 plus communities that are represented on the call tonight. Do you want to mention anything about their ability to restrict?
Yep, great point. Thank you. Yeah, there's a statute that allows, as long as you kind of check the boxes on some things, that you can restrict to a 55 and older community. And in that case, there are reasonable rules about children not being there or minors not being there. Yes, that is legal.
Okay, starting kind of back at the beginning, we have a homeowner who abandoned their property in August. It is currently in the foreclosure process. But this particular board member has stepped up with other neighbors to take care of the overgrowth, regular mowing, etc. In the future, how can we see that that is properly maintained while abandoned and ensuring cost is passed to that homeowner and or unit?
Yeah. Now, I have to preface the answer to all these questions, of course, with the disclaimer of I haven't read the documents. I don't know all the facts. So these are just kind of off the cuff responses. You expected that, I know. The answer is this. Abandoned houses are very, very difficult. There is almost no way to make an owner who is gone do it. There's almost no, well, there is no way to make a bank, the mortgage company, do it while they're foreclosing. And so there's really nobody to go after effectively. And so the answer is what you guys are doing. You know, I would rather have a volunteer group of people that aren't board members and aren't committee members do it. Maybe the neighbors on either side can get together and take care of it or mow it. But, you know, if board members do it, then you got the argument of maybe the association was involved in that maintenance. And where my mind has to go as a lawyer is when the president's out there mowing the grass, trying to do the right thing, and a rock flies out and puts out little Susie's eye who's walking by, was that an association action or not? So let's try to keep board members and committee members out of it.
Okay, next question. We've been told by our attorney to never call the homeowner and send a letter, and only to send a letter. We've been instructed not to enter the property without prior approval of the homeowner as well, which you talked briefly about.
Yeah, I agree that phone conversations never work out well. Okay, because what you say is not what they hear. I promise you. So yeah, phone calls are not good. Now I didn't understand the go into the house issue.
I think that has to do more with self-help, and going on someone's property. You talked a little bit about that.
Yeah, and let me just put a punctuation mark on that. Your documents may be very clear that after 20 days notice, you can go in and abate the violation. You can clean it up or correct it. My advice remains, don't ever do that. The safety issue, I mean, I've had situations where people have done it and people have come out with guns. I mean, it happens. Just not worth it. We've got other ways to do it.
Yeah, there was a board member killed, I think, in Raleigh 3 years ago, and I think another board member about 10 years ago killed in Charlotte. So,
Yeah, I mean, it's a reality and don't do it.
yeah. How do you establish that you actually placed the letter in the U.S. Postal Service box?
Somebody has to say, I did that. I put it in the tray that goes to the post office, or I put it in the mailbox myself. You have to have somebody that's able to say that. And surely you do if it was done, and willing to sign an affidavit if necessary that it happened.
Okay, before I answer or ask the next question, I want to say it is 5:30, and I know we advertise these going an hour long. So if you do need to leave, feel free to jump off. But I will continue to answer or ask some questions. And I think, Steve, we said we'd go to about 6. So depending on how many questions we can get through. So regarding violations, should owners be fined if they have architectural violations? This example, they put a shed with no fence prior to the time the management company was hired.
So I'm presuming that the application was a shed and a fence approved, and they only built the shed. That's what I'm presuming has happened. Uh, I think that's technically wow. They've chosen not to do the fence, let's say. They built a shed and that's in compliance. That was already approved as part of the deal. The argument would have to be that they were conditioned on each other. You have to build both. You can't build one. That would have to be the argument. Um, that's really fact specific. I have to look at that. Yeah, I'm
So,
sorry.
okay. Well, in North Carolina, can the violation fine only be up to $100 total for the fine or a daily fine of $100?
The North Carolina statute is really clear, thank goodness, and it says you can fine up to $100 for the violation, and after a 5-day grace period, up to $100 a day. And I want to take a moment because I thought about putting this in here. It's so important. The trash can problem, okay, or the boat trailer problem, or the RV problem, the things that come and go. Okay, that's the problem. If somebody violates your trash can rule, okay, your trash cans have to be in by Monday morning at 9 or whatever the restriction is, and it's not, and they're in violation. You can call them to a hearing, and you can fine them. I'm sorry, let me back up. The facts. January 1, they're in violation of the trash can fine. Okay. It's supposed to be put away. January 3rd, they put it away, but they were still in violation on January 1. We still have that. So we could have a hearing January 20th and say, yeah, you were in violation on January 1st. Yes, you corrected it on the 3rd, but you were in violation on the 1st. And when that happens, you can fine them up to $100 for that violation on January 1. Okay. A lot of boards kind of get tangled up in or the homeowner comes in and says, whoa, it's not a violation now. Go look, there's no trash can. I put it back. I cured my violation. Well, yeah, but it was in violation on the 1st. But you can't do the daily fines, obviously, because they put it back. So you're basically stuck with one fine of $100 or up to $100.
Okay, if the documents state escalating fines, $10 for the first fine, 25 for the second fine, and $100 for the third fine, should the board follow the state law or the documents?
Yeah. If you are unlucky enough to have that kind of scale baked into your declaration, you have to follow it.
Handicap ramps. You talked a little bit about handicap ramps. Do they have to be approved, and are placement restrictions allowed?
Excellent question. And I'm going to kind of dodge and weave on this, obviously. I can't give you a blanket yes. It's very fact specific, but the steps are, one, is the person handicapped? Okay, you have to do that analysis. If you've always seen them in a wheelchair, you've never seen them walking around, it's clear that they are handicapped, then that checks the first box. Second box is the request reasonable to accommodate their disability? Okay, so a ramp going from here to there, is that reasonable? Let's assume it is. Got to have a ramp, otherwise, they got to go down a curb. Can you do a location restriction? They want it right outside of their unit, and that's problematic for some reason. Can you say, we're going to give it to you, but we're going to give it to you, 4 feet over here or 6 feet over here? That's where the reasonableness issue comes in. I said reasonable accommodation, reasonable modification. And that's up to a judge or a jury in the end, whether it needed to be there or 2 feet, 4 feet, 6 feet, 12 feet away. What's reasonable? So the answer is probably yes, you can do some location discussion, but it's got to be reasonable.
Okay, architectural question. In our county regulations state the shed has to be at least 10 feet from the property line, and any structure greater than 12 by 12 needs a permit. When the HOA reviews each ARC request, are we responsible to ensure that they communicate those requirements to the homeowners and meet county requirements in the ARC approval?
Thank you for whoever sent that in. Thank you for that question. No. My strong recommendation is that the association not be involved in any kind of municipal requirements, permitting, municipal setbacks. That's not our job. Okay. Our job is to make sure it is compliant with our governing documents. And we have a lot of leeway that way. Let me tell you why, because that feels counterintuitive. I understand. If we get into, well, do you have a permit? Or if we get into, have you followed the setbacks? And when we screw that up, that creates a whole group of liability issues that we don't have to have. Okay, let me take it a step further. This came in last week, actually. Association person wanted a shed, fine. Person wanted to put lighting in the shed. It was going to be a workshop, fine. They wanted to know the electrician that was going to be used. We want to know the contractors you're going to use to put in the power. I hope everybody on the line here understands how dangerous that is. Number one, why do we care? Truly, all we care about is what it looks like, the shed. And two, let's say they tell us it's Jimmy Smith, the electrician, and we sign off and approve it, and then little Susie gets injured when it catches on fire because Jimmy Smith did it wrong. Guess who defendant number 2 is? The association, because we rubber stamped it. We approved Jimmy as an electrician. Stay as far away from that as you can.
Okay, 2 term related questions. One, can the board extend their terms without the association okay? And when does a term actually start? At the annual meeting or say January 1st?
Unless your documents say something different, which they can, but unless they don't say something different, then the terms begin upon election. So if Thursday night at 6 is the meeting, the annual meeting, you get elected. Thursday night at 7, you're on the board. 2, I don't think I've ever seen a set of bylaws that lets the board extend their terms. So if it's a 2-year term, your term is up in 2 years. Somebody else gets a chance to be elected to that position. You can probably rerun if you want to stay in, but it has to be elected. I think I know where this question is coming from, though, because what if Steve gets elected to a 2-year term? Okay, it's Thursday night. I get elected at 7 o'clock. I'm the new board member. And then 2 years later, it's time for my term to be up. But nobody wants it. Okay, nobody's elected. Nobody volunteers to step forward. Okay. My argument is, and I think it's right, is that I do get to stay in that position until my successor is elected. Okay. Now, that may be as long as the following year. Maybe that the next annual meeting, somebody's interested and gets elected. Then did my term get extended? I don't like to use that word, but I will say that I stay in my position until my successor is elected.
Okay. Next question is about, we'll call them workshops. We like to hold workshops and do some brainstorming in advance of our meetings to develop, kind of the agenda. Um, is there a proper way to hold those meetings, and do they have to be recorded, um, and motions adopted for formality?
Yeah. What I would say that is a committee is really what you've done. And committees do not have to take minutes. You can, but you don't have to take minutes. But that's what I would call that. And there's no formality to it, Robert's Rules of Order or anything like that. You can, but you don't have to. If that was the question.
Yep. So what do you do if you do not have the required number of elected board members? In our example, we only have two seats filled of the required five.
Great question. The two of you are driving the bus. The two of you have all of the power of the association. Now, the tough part is you have to have a majority vote to do association business. So both of you, every time, all the time, have to agree. Okay, because it's majority. That is legitimate. Okay, it's fine. But I would strongly recommend that you take some efforts to get those positions filled. Okay. 90% of the time, you have authority to appoint people to a vacant position. You don't have to have an election. You don't have to have a meeting. You can just say, hey, neighbor Bob, would you like to be on the board? And if Bob's a good choice, the two of you could appoint Bob to the position. And you should try to do that. I think it would be a very bad look. Let's paint this terrible picture. You got two of you. The two of you decide to do X, whatever X is. Deny the shed, deny the ramp, do something. And you get sued. The plaintiff's lawyer is going to make a big deal about when did you try to fill these positions? Well, we had an election last, 6 months ago, but nobody stepped up. Well, okay. Have you asked around to people? Have you sent out a mailing looking for people who might be interested in being appointed? So I think you should try some effort to fill those positions.
Okay, you mentioned unanimous decision making through electronic voting. If a meeting is called outside of a regular meeting and we need unanimous consent, what if the business pertains to a board member? Would the board member in question have to recuse themselves? And do they have to vote?
As long as conflicts of interest are fully disclosed to the board of directors, they don't have to recuse themselves. Let me start with that. Okay. My brother-in-law owns this landscaping business we're talking to. Full disclosure. Then I don't have to recuse myself. Is it a good idea that I do? Probably. So if I do recuse myself, then that vote would not be necessary to get unanimous consent.
Okay, in the minutes, would you recommend documenting who voted for what for transparency, or just recording the vote passed 4-1?
Yeah, that's a really good question. It's not legally relevant who voted how. So, I would lean towards why put it in there? What's the point? So leave it out. Is it inappropriate to put it in? No, you can put it in if you want to. I don't know what good it does. It's a corporate decision that was made.
So some publications recommend including the agenda in the minutes to create a record of the meeting topics. What are your thoughts on eliminating the minutes and the agenda being separate from the I guess the final minutes that were passed?
It would be unusual to include the agenda in the minutes. You can. You absolutely have to have minutes. I would say I might have seen agendas as part of the minutes 3 times in my career. So it's never been helpful, but it's never been harmful to us.
So in executive sessions, do you need to have minutes, and how do you record them?
Yeah, good. Yes, you have to have minutes. And there's a couple different theories on how this is done. One theory is, let me paint the picture. 5 of us are at the board meeting. We got a couple of homeowners there. We have a sensitive topic. I, Steve, make a motion. I move that we go into executive session, seconded by another board member, voted on, approved. So we go into executive session. Okay, that's kind of the way it can work. Members have to stay out. We have a full discussion in executive session. Discussions are not recorded in the minutes. Remember, who said what isn't recorded. Here are the 2 ways it's done. One way is to actually vote in executive session. Okay, I make a motion that we fire the landscaper, or that we, sue Stan. Seconded, that business is done in executive session minutes. The board of directors voted during executive session to file a lawsuit against Stan for X. Okay, that's executive session minutes. That's perfectly fine and appropriate. The other way I've seen it done, and it's okay, is to have all the discussions during executive session and then go back into the main meeting to make the motion and vote. Okay? And it really depends on the sensitivity of it. I'm more comfortable with voting in executive session. The other side of the coin, though, is that secretive? Is that hidden business? Is that, are we not being transparent? Which was kind of the point of the question.
Okay, you may like this one, but what's your view of having minutes for the board's eyes only, and then other minutes that are cleansed, that get distributed to the homeowners?
Happens more often than you would think. Don't do it. That's all. Don't do it. That just breeds problems. How am I going to explain that in court if I have to? Well, we were doing business, but we only wanted to tell people some of the business.
And I'll say, wouldn't it all be subpoenaable?
Oh, yeah. Great point, Ben. Nothing you do is going to be secret in litigation. Let me just be really clear about that. And let me tell you how broad that is. Not only are your executive session minutes going to be discoverable, and when I say discoverable, they can subpoena the information, they can ask for requests for production of documents in litigation, but the texts that you send to the other board members, the emails you send to each other, not even to all of you. Steve, I want to see I'm subpoenaing all the texts that you sent to the other board member, Stan, and just Stan. They get them. Be careful.
So do town hall meetings need meeting minutes and a quorum?
Yes. They are a corporation, a nonprofit corporation, and the corporation has to have quorum and majority votes for business.
If it's an informational meeting, does it need just to share information?
Yeah, no. Informational meetings do not have to have quorum, but keep in mind, informational meetings should also not be conducting any business. There's no voting. It's just information. It's a good question.
Okay, you mentioned HOPA, and are there any fair housing minefields that we need to be careful of in a 55+ community?
Don't discriminate, or don't treat anybody differently that's in a protected class: age, race, sex, handicap, familial status, national origin. That's the bottom line. It's been a long time since I looked into the HOPA restrictions on children. I do not believe that you can strictly prohibit them. I mean, like forever. No children can step on the property. I don't think you can do that. It's a reasonableness scale, if I remember, because grandkids want to come and all that kind of thing. But I'd want to look at that again.
Okay, pool-related questions around fair housing versus safety. And this is a regular question that comes up, but when does safety and common sense with safety overrule what's required in fair housing? And maybe talk about some examples on wording that you've used.
Yeah. And I'm smiling because I love that question. Very popular question. It makes no sense to me or you that someone can drop off their 8-year-old at the pool at 9 o'clock in the morning by themselves with no supervision, um, and the law be okay with that. Okay. The answer is there are things we can draft in the rules and regulations that are not based on age, but based on skill level. For example, I've drafted lots of pool rules that say, was it, people that are unable to swim proficiently must be accompanied by someone who can swim proficiently. So we're saying the same thing, just differently. We're not talking about kids or age. Now, here's the minefield on that one. How do we know who can swim proficiently? I've had questions of, do we give them tests to see if they can swim? I don't want to go there. That puts us on the hook even more, I think. But it's things like that. You can word things. No personal property in the pool. Here's one of my favorites. You don't want toys. You don't want kids throwing toys and, dangerous people putting out eyes with things that kids are throwing around. So personal property in pools shall be limited to, floats of this size and shape, maybe. I mean, you can, because that applies to adults too.
Yeah, I think, we talked a little bit about diapers, right? And, I think instead of, all children must wear swim diapers, you change it. So any person that can't control their bowels must,
Any incontinent persons must wear appropriate clothing. There's the magic. That's the way it works.
yes. Okay, changing topics. Regarding not utilizing professionals, what are your thoughts on having folks that live in the community that may have been professional carpenters or electricians and they want to help the community by volunteering their time? Can we use them?
That is a really tricky question because it's so compelling to use them. I mean, if they're willing to give up their time and experience and expertise to help out the association, don't we want them to do that? We do. But the risk is you got to always think about little Susie. I know I use that too much, but Billy was a carpenter for 20 years, retired, in great health, wants to help, work on the deck outside the clubhouse. Let's just let him do the, $2,000 worth of work on that Saturday. Okay. What are the problems with that? Number one is when Billy accidentally drops something on Susie and injures her. Okay. Who's on the hook? The association, without a doubt. Okay. Billy doesn't have insurance, I'm sure, or commercial insurance that would cover that. We're on the hook. Billy doesn't do it right for some reason. Maybe he just makes a mistake and makes it unsafe and unstable and the deck collapses and hurts little Susie. Guess who's on the hook? Us, the association. And I will tell you, I'm not an insurance expert. You need to talk to your insurance agent. There may be exclusions for volunteer help. So if you have volunteers helping you, you may not have insurance coverage for that. So when Billy helps with the deck, maybe no insurance at all. So when little Susie gets hurt one way or the other, that's a problem.
Okay, we have about 5 minutes left, so I'll try and get through as many questions as I can. If homeowners are consistently delinquent with their dues, and they rarely have a balance of zero, how long should the board continue to accommodate this owner, especially if the association begins to have additional homeowners repeatedly come delinquent?
Yeah, this perfectly fits into the second slide for tonight. Treat everybody similarly. Okay. Now, that doesn't mean that you have to treat the habitual delinquent person just like the brand new delinquent person that's never been delinquent before. That's not what that means. What it means is maybe you have a policy that says we treat new homeowners this way, delinquent homeowners this way, but all of them this way. We treat habitual delinquent people this way and always this way. So you can do that. It's a little trickier. I'd rather you just treat everybody the same. If people owe over $300, they go to the lawyer. End of discussion. I mean, that's absolutely the best policy. But if you truly have habitual people, you need to have a policy on how to deal with them, and everybody that fits into that box has to be handled the same way.
And I'll just add, every community that we work with, we try and get a collection policy established. So if you need a copy of your current collection policy, ask your manager and we can probably supply that for you.
Yeah, no, I love that. But yes, policies, very, very helpful.
Okay, parking. People's parking and pets. We made it, we almost got through without talking parking. But for an example, neighbor is parking on the street in front of someone's house, and this is becoming a point of contention between the neighbors. Our HOA allows on-street parking.
This gives me an opportunity to give you a really big answer to a lot of problems through this example. Is this an association issue, or is it a neighbor to neighbor dispute? It can be about parking, it can be about noise, it can be about dogs, whatever it is. Is it an association issue, or is it a neighbor to neighbor dispute, which we're not involved in? Here's how you do that. You take the facts. Here we have parking on a public street, and you say, is there anything in our governing documents of our association that we need to enforce or that exists? I mean, is there something that we can do? If there is, you have to do it. Okay. Under these facts, Ben, I think the homeowner is saying it's a public street. They can park wherever they want to. So we don't have any restrictions to say otherwise. So that's out of the way. The second analysis is anyone claiming discrimination? Okay. Has someone said they're parking outside my house to harass me because I'm Christian or Jewish or whatever the discriminatory class is? If they say those kinds of things, then the new law is we kind of start talking about it and asking some questions. But if there's nothing in the restrictive covenants to address this issue, and there's not for the parking, from what you said, and there's no discriminatory allegation, it is not an association issue. It is a neighbor-to-neighbor dispute, and we tell them that.
And I'll add, I think it was last year, it may have come up 2 years ago, legislation was proposed that did not pass with House Bill 542 that a lot of people adamantly said it wasn't good, but it did have language in there to try and enforce associations from enforcing parking on public streets. And so it did not pass, but it is definitely on the radar. So
we'll see that come around again, I'm sure.
Yep. Is there a requirement to advertise your community's board meetings and when they're going to be held?
I'm sorry, I'm hesitating. There's no statute or case law that requires that. Your governing documents might. It might say you have to give the membership notice of all board meetings, but you'd have to look at your documents.
Okay. Are rules and regulations considered board policy, or are those something else?
Yes. Yeah, the policies were at the bottom of that chart on the hierarchy, and I forgot to say this, is yes, policies and rules and regulations, I see those kind of as the same thing. And those are things that the board of directors can create and change and amend on their own. Okay, unless your documents have something else in them. But 98% of the time, the board can change those anytime they want. But, and this is a whole nother presentation I could do, here's the tripwire. Rules and regulations. Rules and regulations are almost always limited to common elements. You can walk your dog over there. You can park over there if it's private common elements. It does not say that you can make rules and regulations about what people do inside their homes or on their lots, but a private property. That's a whole nother presentation I'm glad to put together someday.
Okay, I'm going to say the last question because it is almost 6, and I'm paraphrasing a couple of questions, but it sounds like we live in a condo and some architectural issues have happened. There's one fence example and one improvements in the condo example. What do you do to enforce the rules, and how do you go after the individuals that are doing something that they're not supposed to do?
Yeah. Well, 99% of the time in a condominium, everything outside of the walls is common elements, and they shouldn't be putting fences on common elements without our approval. But That's a sidebar. I think the question is, what do you do? The slide about halfway through the presentation, I kind of went through the giving notice of the violation, sending them a violation letter, explaining what the violation is. If it's not cured, then go ahead and schedule a hearing, have the hearing, possibly fine them for it. One nuance that I think they're asking about. What if the violation is inside their unit and it's hard to prove? The fence, we can see it. What if it's inside the unit and hard to prove? The answer is the hearing is the place where we're going to try to prove things. So we may not have a picture of what's inside. We may not have strong evidence on what's inside. But many times we go ahead and bring them to the hearing, tell them, hey, we think this is going on. We think this violation exists. Come to the hearing. Let's talk about it. And, if they're honest, then they're going to say, yeah, I put that in my unit. And you can start talking about it.
Okay, well, I do apologize for not being able to get through all the questions. I think we've had close to 70 questions submitted, and there are about 40 open at this moment. So I do apologize not getting through them all. I will say before we close, this is recorded, and we will post the recording on our camsmgt.com website. There are some questions about portal training and upcoming webinars. So we do host these webinars on the third Thursday of every month. So I think I'll be wrong with the date, but yeah, third Thursday in February, third Thursday in March. Next one will be with an insurance agent talking about insurance, rising rates, what we're seeing, and what are the types of insurance every association should have. And then we are working on an FHA ADA presentation in March. So, Steve, we will welcome you back anytime.
Love to do it.
maybe April. Also, if you'd like to give Google reviews, I know we love our Google reviews. So, Steve, I'm sure you accept Google reviews, as do we. So go on Google and support us with those Google reviews. And lastly, portal training. There's some questions about portal training. We can do another webinar on portal training. There is through the board member portal. If you click on the board member tips, we have a number of different recordings. So you can see about 3-minute videos on how to use the homeowner and board member portal within the Vantica software. So if you do have additional questions, get with your manager. But I will also work on getting a webinar together for board portal training. So again, thank you for your attendance tonight. Steve, thank you for your presentation, and we will be signing off. Good night.
Thank you all. Good night.